So now considering the various mechanisms, if you will, for your estate, types of trust in estates. A trust is a legal arrangement through which a trustee holds your assets for your benefit or that of the benefit of your beneficiary. So someone is entrusted with your property, with your assets. So it takes care or manages they're the ones that takes care or manages your property, kind of like an executor, but someone who actually takes possession, does not just pass things through. Used to protect assets from creditors or manage property for young children, etc. All assets are taken out of your name and put into the name of the trust created by a trustor or a grantor. Trusts are either revocable or irrevocable. With a revocable trust, you retain the right to end the trust or to change its terms during your lifetime. And this may avoid lengthy probate process. Remember, probate is where the courts determine what your intentions are, your will, right? Proving the validity or invalidity of that. So this kind of avoids that going through a trust. Someone acts in your interest, in your name. In fact, they're the ones that are entrusted with your property. Does not provide shelter from federal state taxes. With the irrevocable trust, you cannot change the terms or end the trust. So this is once you sign on the dotted line, that's it. You cannot change this. For tax purposes, the trust becomes a separate entity. The taxes are paid by the trust. If it's a large estate, it's used to reduce estate taxes and avoids probate. Benefits of establishing the trust is to reduce or provide payment of estate taxes, avoid probate, transfer your assets immediately to your beneficiaries without passing go, or do not go straight to jail. No, you would be passed. This would be going directly to your beneficiaries, so there's no hold up in the courts. Free from managing assets, free you up from managing assets, provide income for surviving spouse, other beneficiaries, and ensures property serves desired purpose after your death. So this is another directive, but it's something that you would put in place before your passing, right? As opposed to a will where it's executed after your passing. So there are different types of trust: credit shelter trust, also called a bypass trust, residuary trust, an AB trust, an exemption trust. It goes on, or a family trust, disclaimer trust, living or inter vivos trust, property management arrangement established while you are alive. Testamentary trust established by your will, life insurance trust. Moving on to the estate, make an inventory of your estate, cash, bank accounts, etc., stock, and all of your assets that are out there, including the paperwork for your home, other real estate that you may own, any business interest, money that's outstanding that you owe, that's owed to you, interest in any trusts that are out there that are already all set up. Any kind of collectibles that you have, any physical assets, any community property that was acquired, either with your spouse when you're married, so that you can, you can track these things and you can dispose of them, right? This is what you're trying to do. You're trying to redirect things or get things in order so that you can redirect them to whomever you so choose. So joint ownership is typically the case. You may have a vehicle in both persons' names, so a spouse often owns property as joint tenants with right of survivorship. The property will automatically pass to your spouse upon your death with no estate taxes paid at the first death. The first person, anyway, it's not like you're going to die more than once, but the two people, taxes are not paid until the second person passes, is the point. So estate tax is paid when surviving spouse dies, the residuary. So the tenants in common, each individual is considered its own proportionate share and can choose who gets their shares, if you will, at death. Tenancy by entirety: when one spouse dies, the other gets the property automatically. Life insurance and employee benefits are free from probate and income tax, so keep that in mind. So assignment of ownership to your beneficiary can remove a life insurance policy from your estate. Unless payable to the estate, death benefits from qualified pension, profit sharing accrual plans are excluded from your estate. Okay. So lifetime gifts and trust, what we're here is that this is where there are stipulations involved, where there are strings attached. Control of property are fully included in your estate at the date of death value. So whatever that value of that painting is worth at your passing, and not what you paid for it, but at your passing. If you are the beneficiary of a trust established by someone else, you have general rights to the principal during life, or the power during the principal rights to the principal during life, or the power to appoint it to anyone at death, and that amount is included in your estate. Settling your estate. So if you had a will drawn, your testate in the eyes of the law, meaning that you have your testament out there. So this is that when you say that you are testate, that means that everything's in order. So you have an executor, and you've declared your will, and you've signed off on it and had it witnessed, etc. So if you're not named an executor, the probate court will appoint an administrator. If you don't have an executor, will probate an administrator to carry out the instructions in your will. If you don't have a will, you become intestate at your death. Your estate is put under the control of the court-appointed administrator for distribution according to the laws of the state in which you reside. Some assets pass outside the will directly to your beneficiaries. Others do not. Others have to go through the court process, right? So for the states, you're on the hook, of course, for federal estate taxes, and the number's quite high, so it typically does not. Most people don't pay federal estate taxes. State inheritance taxes, similarly, federal, state, and state gift taxes, tax avoidance, evasion, charitable gifts, bequests. All these are, again, part of your estate. Calculating tax and probate administrative costs, and paying taxes that you owe, that you owed. All these have to be settled in your estate, right, as upon your passing. Do you have to pay taxes on estate? Yes, so long as if it's in excess of, again, in 2022 is $12 million. I think I've got it higher now. I think it's about $14 million.